Good evening, everyone. Again, as usual, we are back with our regular webinar on IBC, decoding of IBC. And we this time has thought over of discussing recent judgment, important judgment as regards IBC, including disciplinary committee. Friends, that is also crucial, which guide us how to do what, and that is very crucial. And hence this webinar for discussion. We have with us our panelist, Mr. Srinivas, Assistant General Manager, SIDBI. Welcome, sir. Thanks for
good afternoon. Good afternoon to everyone.
Thank you, sir. We have with us Mr. Devendra Umrao, Associate Partner, Mehta Insolvency and Restructuring LLP. Mr. Devendra is a professional lawyer and IP. And since years in practice, being a partner, I will not introduce him much, but of course, our invitee panelist, Mr. Srinivas, I'll introduce formally. Mr. S. Srinivas, Assistant General Manager, has done graduation commerce and MBA finance from NIT Tiruchirappalli. He joined SIDBI in 1998 and has more than 25 years of experience across different functional areas of the banking sector. My goodness, sir, thanks a lot for your time. You have enriched experience. Thanks a lot for your time, sir. Thank you. And we help.
I'm honored, madam. I am honored to be on the panel today. Thank you so much for that.
Thank you, sir. I'll request you, sir, to say a few words on the this topic or IBC for 1 or 2 minutes, and then Mr. Devendra, and then our presenter, Ms. Asta, will start presentation. We also have with us our designated partner of LLP, Mr. Atul Mehta, who is also insolvency professional, and other partner, Mr. Hemendra Paliwal, Mr. Himanshu Kapadia, and all are invited. Yeah, sir. Mr. Srinivas, your few words.
Thank you, Dipti, madam. The banking sector is evolving. That is what I should say. Like, I've seen it for the last 25 years, and now the banking sector is at its peak, I would say. Most of the banks, which had huge piles of NPAs till recently, maybe till you can say 2015 or so, they have now started seeing a turnaround in their business because of the recoveries that they have been able to make. The NPA levels in the banks are coming down significantly. So the banking sector of the country, especially for the public sector, the government actually was considering the banks as vital events. Like, government was required to pump in lots of funds, equity infusion in most of the banks, time and again repeatedly, has now seen a paradigm shift. Now these banks are becoming a good source of income for the government. They have turned around, their NPA levels have come down, so they are generating profits. They are making huge dividend payments to the government of India. They are becoming more bankable. Banks are becoming more bankable, and maybe IBC has a very good role to play even in future. Like, to some extent, we can say this turnaround in the banking sector has come because of IBC. IBC, though it is still in an evolving phase, has shown a lot of developments in the banking sector. So because of this IBC process, there is a kind of moral suasion which is happening in the minds of the defaulters. So there is something called IBC. I have to go to the negotiating table of the bank. I have to make some payment and settle my account. So something or the other, like if not the entire repayment, some settlement is happening. And that is actually the main reason for the banks turning around, and they are, at one point of time, they were in losses. Now they are again back in the black. Like, they are not red anymore. So all this is happening because of the IBC process and the professionals who are sincerely contributing to the IBC process all the RPs, I know like it's not so easy. Any resolution, takes a lot of time, patience. All the RPs have to put in lots of efforts, and sometimes they even risk, their personal safety. All these things do happen because all the borrowers are not very good, not cooperative. So all this is happening because of the RP's commitment to the sector, and IBC, which is understanding the business environment and evolving the sector with its modifications and guidelines from time to time. And all the people who are organizing this kind of awareness programs for the sector and enlightening the banking sector. I would say even among the banks, the awareness levels are very low as far as IBC process is concerned. Very few bankers really know the IBC guidelines and the do's and don'ts of IBC.
Okay.
So all these seminars are really useful for the banking sector professionals also, and also fellow RPs. Like, I mean, to some extent they may be knowledgeable, but they may not be fully knowledgeable. Like, I mean, every part of this presentation may not be known to all. So there will be some learning, some insights for everybody who is there today in the meeting or webinar. So with these words, I would request you to take it forward. Thank you.
Thank you. Thank you. Thanks a lot for your words. Mr. Devendra, you would like to say anything, or we'll start the presentation? You are on mute. We can start the presentation.
Oh, I'm sorry, I was on mute.
Yeah.
Okay. Yeah, ma'am, I'm extremely sorry. My apologies. Thank you, ma'am, for keeping me on the panel. I'm proud to be here. I'll just pick up a line from what Mr. Srinivas said, that, RPs may be knowing a lot, but still, at least as you a fellow RP, know that for us, the law and every regulation and provisions are always evolving. So this seminar, I'm sure, will contribute to that. In fact, for example, one of the judgments that we'll be discussing, which will talk about the liquidation process regulations, 21A, subsection 2, regulation 2B, about, mandatory timeline of 180 days in case of enforcing a security interest. So all these things, the judgments as well as what we can learn from disciplinary, I'm sure it will be a value add to all of us in our profession. So look forward to carrying it on, ma'am. Thank you very much.
Thank you. Thanks a lot. Yeah, Asta, you can start the presentation, dear. Thank you. I'll request all the participants, if any question, please put on the chat box. Thank you. Yeah, you can start.
Good evening, everyone. Let's start with the important judgments under the Insolvency and the Bankruptcy Code 2016. The first case that we have is in the case title name, Jayanti Lal Ranshi Singhoi versus Mr. Anuj Bajpai. This was held before the Company Law Tribunal, Mumbai, order dated 28 June 2023. In this matter, the facts of the matter place such as Section 9 and Section 11 application was filed under the Arbitration and the Conciliation Act by the applicant, where the tribunal has awarded the applicant to be paid a principal amount along with the interest on 10th of May 2019. Subsequently, the company had later gone into liquidation and the RP had called for claims, invited claims on 9th of May 2023. However, the liquidator, while had called for these claims, he did not receive any claim from the applicant. Later, when the applicant came to know that the company is under liquidation, he immediately filed his claim and submitted it to the liquidator. Due to delay by the applicant, the liquidator did not accept the claim of the applicant and thus rejected his claim, to which he submitted that the liquidator cannot commence the distribution process before the list of stakeholders and memorandum being made and submitted before the adjudicating authority. As per Regulation 42 of IBPI Liquidation Process Regulations 2016. Thus, no prejudice would have been caused to any of the parties in case if the delay was condoned. The bench held that since the award was passed in 2019 and the CIRP commenced in 2021, the RP should have taken cognizance of the same and thus ordered for delay of such condonation. Also said that the bench should note that the liquidation process regulation does not contain any provision dealing with the belated submission of claims, and it should not be adjudicated on technicalities but on merits. Thus, the condonation of delay was allowed by the court.
Yeah, next.
The next matter is in the case title Bank of India Limited versus BD&B Hotels Private Limited. This matter has been taken up before the Company Law Tribunal, Mumbai, order dated 23rd June 2003. Now, in this matter, certain documents which were in the name of loan documents, mortgage deed, and certain term loan agreements were signed between the corporate debtor and the applicant. While these documents were executed, later, due to non-payment of all these agreements and all these loan accounts, the accounts had turned NPA. The corporate debtor in this particular matter has challenged the maintainability of this petition on the ground of insufficiency of stamp duty being paid on the loan and mortgage documents. It has been said that an instrument which is not stamped or insufficiently stamped in accordance with the Stamp Act is not an enforceable instrument and hence is a void in contract as per the provisions of Contract Act. Accordingly, such an instrument cannot be taken in evidence by the court. To this, it has been held that the court ordered that even if such contract is unstamped or insufficiently stamped, the decision lies such that the stamp duty should be paid by the lender, which is recoverable from the borrower, that is the corporate debtor in the present case. The bench is of the considered view that the interest of the state shall be protected in case the RP or the IRP is directed to notify the collector of stamps to file its claim for deficiency in a stamp duty in case there is objections raised by the corporate debtor. Thus, the present petition deserves to be admitted and the amount which is insufficiently paid as stamp duty shall be paid and shall be completed in full.
Yeah, basically that even though document is not properly stamped, it is admissible for IBC purpose. The content of the document doesn't become invalid. Yeah, please go ahead.
The next matter is in the case name of Federal Bank Limited versus Ruben George Joseph, that is the liquidator of Latino Classic Motors India Private Limited. In this matter, the applicant was a secured creditor who opted to realize its security interest by filing Form D of Schedule 2 of IBBI Regulations 2016, wherein the immovable secured asset was under the possession of the secured creditor. The company went into liquidation on 27th of December 2022, from which 180 days was granted to the applicant to realize the amount as expected by the provisions of the law. Here, the applicant has narrated that the pending of these writ petitions were filed before the court by the erstwhile director of the corporate debtor. However, there was no stay and the applicant had thrice issued notifications to auction the property, but the sale could not be succeeded because of the want of bidders. Now, this application, which has been filed by the applicant before the tribunal, is for extension of time. The court ordered that the time period of 180 days that is prescribed by the Regulation 21A subsection 2 subsection B of the IBBI liquidation process is mandatory or directory in nature. Thus, when there is no consequential result, it is prescribed that it will be considered only as directory, and when there is a consequential result, it will be prescribed that no provision is mandatory. It has been held that if the period of 180 days has been expired, the secured creditor has failed to realize the amount and has to pay to the liquidator, the secured asset shall automatically vest with the liquidator and it should form part of the liquidation estate. Thus, according to the order given by the court, the application is dismissed.
So 180 days is mandatory, and if they cannot realize in that, it cannot be extended, and the asset will form part of the liquidation estate. Right? We can go ahead. Yeah.
In the next matter, the case title is V. Duraisamy IRP of Messrs. HSG Dairies and Agro Limited versus Jaipriya Fruits and Vegetables Commission Agent. In this matter, the corporate debtor was ordered by the adjudicating authority on 20th January 2019, wherein the IRP had checked that the master data of the corporate data was struck off by the registrar of the companies due to non-filing of returns. The RP had only received claim from one operational creditor. Further, the IRP after receiving claim from the operational creditor, he was required to constitute the COC with a sole operational creditor. In such matter, the adjudicating authority had ordered that the IRP shall move an application before this tribunal to restore the name of the company under Section 252 of the Companies Act, which, however, the IRP has moved an application for dismissal of the CIRP more particularly. The decision of the appellate authority in this matter was held as there is no provision in the code for the corporate debtor to constitute the COC with a single operational creditor, where it is seen from the record that despite the public announcement and the claims that had been called for, only a single claim had come forward. After making this public announcement, not only a single claim, but the COC cannot be constituted on this ground. The corporate debtor's name has already been struck off from the registrar of the company, and this tribunal is of the considered view that the IRP may be closed with respect to subject company. The appeal was allowed and the order of the adjudicating authority earlier was set aside. The company is released from all rigors of CIRP.
Here though the comment of one sole operational creditor constituting COC is something can be discussed or debated, but the thing that the company was struck up, so there was nothing in the company, and that's why the view of the facts, I think, circumstances, the appellate tribunal has took the view. But we cannot comment much on that, but I think there are instances known where the COC were constituted with one operational creditor. Okay, yeah, ask.
The next matter.
Panelists can comment anytime when they feel, please.
The next matter is in the case name Consortium of Prudent ARC Limited versus Mr. Ravi Shankar Devarakonda, the RP of Messrs. Meenakshi Energy Limited and others. In this matter, the RP had filed an extension. RP had filed to rerun the EOI process, and for which a time period had been allowed for extending its period to a limited time, wherein during this extension, 3 resolution plans were received in the name of Jindal Power Limited, Vedanta Limited, and the applicant who has made this application. Now, the applicant has given its question in the name that he has contended that the regulation 39(1)A of the CIRP regulation is being objected in this particular matter, to which the NCLT has given its opinion, as the COC had asked and conducted a Swiss challenge process by passing a majority of 99.18% in its meeting, and this challenge process was supported by certain clauses of the RFRP, and such that the voting lines were conducted within the timeline as provided by the COC. Further, it also says that the COC has approved the resolution plan of Vedanta Limited, and thus the court does not find any violation of regulation 39(1) A of the CIRP regulations or any other provisions of the code. The court also says that they do not see any substantial reason to interfere in the well-considered order of the adjudicating authority, and thus the company appeal was accordingly dismissed.
Yeah, Asta, go ahead. Commercial wisdom of COC resolution plan is always accepted by Honorable NCLT.
In this matter, the case title is Pussant Towers India Private Limited and Nuon Towers Limited. In this matter, an impunged order had been passed by the NCLT Hyderabad bench, and the application was filed by the resolution professional under section 31(1) of the IBC code, seeking approval of the resolution plan and initiated the liquidation process. Now, the original order that was passed by the adjudicating authority was that the ARC in the name of Invent Asset Securitization and Reconstruction Company had submitted a plan in co-applicant with Messrs. Longview Resources Limited, Hong Kong. However, without the prior approval of RBI under section 10(2) of the SARFAESI Act was not taken. Even though all the conditions of section 29A had been satisfied, the court was of the view that the prior permission of the RBI should have been taken, and thus the order was passed that it should be held as a conditional plan. The applicant further took this forward to the appellate tribunal, whether the prior approval of RBI is actually required or not, to which the NCLAT held that it is significant to mention that section 238 of the code will prevail over any of the provisions of SARFAESI Act 2002 if it is inconsistent with the provisions of the code 2016, IBC 2016. Therefore, the adjudicating authority not to have placed any reliance on section 10 subsection 2 of the SARFAESI Act, wherein the COC itself had given its majority, and in its commercial wisdom, it is non-justifiable in the instant case we do not see any material irregularity. Thus, the liquidation order was set aside and the adjudicating authority was remanded back for the approval of the resolution plan.
So here they have allowed that IBC provision prevail over SARFAESI Act and ARC to be a resolution applicant do not require prior RBI approval. And so that's why the resolution plan, which was jointly applied by ARC was and approved by COC was allowed to be approved and liquidation order executed, right? Yes, go ahead.
The last case for today is in the case title name Messrs. KK Ropeways Limited versus Billion Smiles Hospitality Private Limited. In this matter, a section 9 application was filed under the IBC code, wherein an operational creditor had a total sum of claim of rupees 23 lakhs. However, earlier already proceedings were being continued under the Arbitration and Conciliation Act 1996, to which the corporate debtor had preferred an appeal before the High Court. The NCLAT in this matter had given its decision that as far as the present case is concerned, the tribunal points out the award that has to be come from the rental dispute, and when the appeal was filed by the respondent against the award, the operational debt can only be considered under a dispute as it is considered by the tribunal. It cannot be gainsaid that for initiating a CIRP against the corporate debtor, there ought to be no real dispute existing between the respective parties to the debt owed in this question. So as long as the arbitration award was challenged under the relevant section of the Act, the operational debt in the instant appeal is considered to be disputed. Thus, arbitration proceedings and insolvency proceedings cannot be considered together at one time.
Yeah, so here basically, Master, I think the court took the view that because the ex parte award has already been challenged by the corporate debtor, so obviously there is a running dispute and pre-existing disputes are not allowed under section 9. So that's the view they took, which seems to be the right view because of the challenge which was already being raised by the CD for the arbitration award. Right. So with this, I think we've come to an end for the important judgments. Right, Astha? All these are over.
Yes, sir, we are done with the judgments. We can now proceed ahead with the disciplinary committee orders.
Would we like to take questions for these judgments, or we go ahead with the disciplinary matters first?
Yeah, if they have question, they will put in the chat box. So if any question, we will say. Otherwise, at the end, we will take. Any question, then people can put the chat box, or they can unmute and ask, or we will move to disciplinary committee decision.
I think there is nothing in the chat box.
Nothing much as such, so I think we can move to disciplinary committee. Yeah, Astha, move.
In the first matter of the insolvency professional, the contravention that was conducted was for circulation of incorrect meetings. Here, the insolvency professional had circulated the incorrect minutes to the COC members, and he had treated all the resolutions as approved in absence of the confirmation by the members of the COC. The analysis and the findings of this matter comes ahead, as the minutes of the meeting shall be circulated to all the participants within 48 hours of the said meeting. However, the RP or the IP should not have mentioned the facts about the meetings that were circulated, instead of recording and circulating the minutes as resolutions were passed. It was held by the disciplinary committee that the RP's registration was suspended for a period of 1 year.
Basically, since actually in this case that COC member asked the 2 days time to give their comment or resolution, it was not e-voting, but it was a physical meeting, and voting has to be decided at the meeting. So COC member asked the time of 2 days. So after 2 days, within 48 hours, you have to circulate the minutes. But the respective COC member was not able to give the comment, whether they accept or not accept. Then the concerned IP circulated the minutes with the minutes that the resolution is passed. Instead of stating that the COC has not commented, and whosoever voted should have been accordingly, exact picture should have been recorded in the minutes. So that's why it was taken that RP cannot sit just by drafting minutes in the chair of the COC member and decide the voting and record it. And it was taken seriously, and disciplinary action was taken. Yes.
But then the silence also can be 2 days been given, and none of these COC members have responded. So of course, as an RP, what do I write? I
You have to write that the resolution is not passed because they have not commented. You have to reproduce exact facts. Our duty is to reproduce the facts in the minutes. What event happened in the meeting?
Yeah. So Dipti, according to me, there should be, we can think of two scenarios. If the resolution professional requested the COC that if you do not come with your suggestion within 2 days, then the particular thing is deemed to be passed. In that case, he should have mentioned in that particular meeting.
No. This cannot be. This cannot be. Yes. This cannot be.
It can't be this way, sir.
It can't be that way because you cannot say.
No, then the resolution professional must say that unless you comment here, I have no option but to circulate the minutes.
Yeah, you have to circulate. Yeah, please.
No, it's fine, ma'am. Yeah, you will circulate the minutes, sir, but we cannot circulate saying that the resolutions are passed.
In that case, what is the fate of the resolutions?
No, see, normally what will happen in a practical situation, let's say if I were there, I would get in touch with the COC members, ask them if they need an, extension of voting time.
Correct.
Right. So all that I will document. I'll put it
But
on
here
mail.
it was physical meeting. That was the issue. No e-voting.
Okay.
The provision
no,
is when
still-
they have not voted in the COC, then it should have gone for
Exactly.
e-voting, I think.
No, e-voting
With
or
the time extension. With the
yeah,
time
or he
extension.
could have circulated ballot papers and said that since you've not voted the meeting, I am circulating the resolutions with ballot papers and giving you
So,
so
sir,
much
there
more
is
time.
no provision for the ballot paper in the IBC, I think.
So
Right, but-
basically, he has to write that they did not voted at the meeting and do not express any opinion, ask the time. And if in that meantime they would have communicated in writing, fine, he could have still taken. But since there was no communication, the facts should be reproduced.
Right.
Yes, and the resolution could have been deferred.
Yeah, and then next meeting you can convey immediately next meeting for that.
Correct.
Means at the least, I mean, in any case, you cannot say that they are passed. That is, that
That
is absolutely.
was
for sure,
taken very
yeah.
seriously.
Yeah.
But as per IBC, if there is no voting, I mean, nothing, I mean, they abstain, COCs abstain from voting, it is considered as no. So resolutions are not passed.
Right. Resolutions are not passed. That's what I'm
As per the
saying.
provision of IBC, resolutions are not passed.
You can't say that they are passed. That's
Yeah.
what I'm saying. Yes, sir. I agree.
Sir, my thing is, suppose if 10 people are there, 3 people are absent, okay, and 3 people forming only 10% of the total, out of which 1 person having only 2% of the share, which you ask for 2 days. In this case, how the majority people's resolutions can be stopped?
Yeah, so you are telling that majority has passed, one participant has not voted, right?
No, only 2% did vote, it seems.
Yeah. Suppose if the person who, no, in this case, if that person, the financial creditor having only 2% of voting share, and he said he wants 2 years, it is not going to make any difference.
So whether it is difference or not, we cannot enter the shoes of any creditor and decide whether they voted in favor or against. We have to
See, most of the things what happened, the payments which has to be to the CRP cost, they said they as per the circular of the IBBI that the person who is attending the meeting should be a deciding factors. Most of the FCs are not making that. It is not a fault of an RP to say that, okay, I will go back and get that consent. In such case, how we can decide? It's a time-bound job.
So if it is by majority passed and some percentage did not voted, so we will say that they did not voted. And that way, if majority in favor, the resolution is passed and you write that this person not voted.
Here it will be taken as abstain from the voting.
Abstain from voting.
Abstain means no.
Yeah, the same way.
So it should not have been passed.
Yeah, what is the fact that they have not voted or abstained from voting?
Mr. Arora, from what I could understand from the query of, I can't remember the name of the gentleman, he's saying the majority have already voted and only this 2% share
That was
holding.
the case.
Yeah.
So that resolution is passed and he has to write the abstain from voting.
Then the resolution is already passed.
Absolutely.
Yeah.
Absolutely.
Correct.
Okay.
So now it means he is victim of 2% only.
Yeah, but we will write that. We have to write that.
Correct.
2% voted only.
Correct.
Okay, that way.
It was taken as approved, right?
Yes, that's okay. Can we go ahead? Yeah. Asta.
Yes, ma'am. The second matter, the first contravention that was conducted by the IP was that when information was called by the inspection agencies, the information was not adequately provided and there was no clarification on the relevant records that were supposed to be submitted. The submissions made by the resolution professional in such was that he had certain personal commitments due to which he was not able to provide the information. Upon analysis and findings, it was found that the circumstances in which the RP was dealing had certain tragic events that stood in the way of dealing with the submitting of perquisite documents in time, to which the disciplinary committee was inclined to take a lenient view on this account. The second contravention was inclusion of claims of promoters without verification. Now, in this matter, the RP has merely admitted claims of landowners on the basis of allotment of constructed area, not on the basis of any financial debt which is raised from them, which was a prerequisite as per the code for any person to qualify as financial creditor. The RP gave his submissions as claims of the home buyers are submitted in the form CA, and upon consideration of such, the amount of flats and commercial spaces allotted in the case of delay of possession. The RP took a legal opinion whether these landlords are classified as allottees or are included in the class of financial creditors, to which an application was also filed before the adjudicating authority, where the opinions weren't the same. The same was challenged before the Honorable NCLAT, wherein it was held that the RP cannot be held guilty for admitting a claim on the basis of an independent legal opinion. The findings of this case is such that the landowners who have entered into a joint development agreement with a corporate debtor should not be considered as a financial creditor due to the collaborative nature of the relationship and the intent of maintaining an independent composition of COC. As per section 5 subsection 8 of the code, it is deemed that this financial debt, if it involves the disbursement against the time value of money, in this context, a joint development agreement where the landowner does not disburse any amount to the corporate debtor against the time value of money, therefore no financial debt is created, and consequently, the landowner cannot be construed as a financial creditor. The third contravention is non-submission of relationship disclosure forms. The IP should submit certain forms of relationship disclosure to the IPA, which were not submitted by the IP in time. However, the IP to this effect was acceptable. The action of the IP to this effect was acceptable by the disciplinary committee. The fourth contravention was delay in submission of the CIRP4 with the board. The form should be filed within a period of 7 days. However, there was a delay of 252 days. Again, the disciplinary committee was inclined to take a lenient view on this contravention, as there was some delay in uploading the form and also a mail had been sent for the same. The next contravention was appointment of an ex-partner and a prospective resolution applicant to manage the day-to-day affairs. Here, a suspended designated partner was appointed as a prospective resolution applicant or shortlisted one as such. The suspended partner was also appointed as an industry expert to carry out these day-to-day affairs of the corporate debtor. The RP says that the appointment of such was done by the COC. The analysis and the findings of the same, where a COC can't hide behind the commercial wisdom to justify its decision to appoint Mr. Vadva as an industry expert, knowingly fully well that the PRA, he could leverage the information related to the corporate debtor to his advantage and avail undue competition advantage. Similarly, RP is in no position to hide behind the erroneous mandate of the COC at this action and was not tenable as per the statute, and he was needed to resist it earnestly. The next contravention is non-verification of claims of home buyers. The board observed that there were claims received for rupees 219.72 crores, whereas the RP has only admitted claims worth rupees 150, has only admitted claims of 152 home buyers. The RP submitted that he was not required to check if the proceeds received from the home buyers are routed through an escrow account, as he mentioned that it was the duty of the bank to check whether these were in their escrow account and whether any red flags were indicated in the same, which the bank has failed to do so. Analysis and finding of the same, that it is the part of the due diligence of the RP to cross-check and verify the claims received from the home buyers The RP has taken, the plea taken by the RP is that he has not been required to check whether or not the proceeds received from the home buyers are routed through the escrow account, and thus the same cannot be accepted. Contravention number 7, not providing the supporting documents with the COC. Certain supporting documents were not provided. It has been alleged that the RP has failed to provide supporting documents along with the notices of the COC meetings, as it is not mentioned with supporting documents and serial numbers of the meeting where the documents have been provided. The disciplinary committee stated that if there was any confusion, the RP should have contacted the inspection agency for such clarification. The next contravention is non-determination of avoidance transaction. Here, as per the transaction audit report, no transactions were found by the auditor which could be covered under the said section. Hence, no violation of Regulation 35A of the CIRP regulations were seen, and submissions of the RP to this effect were acceptable. The disciplinary committee gave its final decision that the registration of such RP was suspended for a period of total of 2 years.
So I think here probably we can go back if you want to discuss, each contravention. However, one thing which I noted, and we as other fellow RPs who are here need to take note of, Astha, there was a contravention number 2. Can you go to that about the inclusion of claims of promoters without verification? So here, if you notice, in the submission by RP, the last para says that an application was filed before A by other financial creditors, and the same was challenged before Honorable NCLAT. So even NCLAT has held that the RP is not guilty for admitting a claim on the basis of an independent legal opinion. Still, if you go to the findings, can you move to the next slide where you have summarized the findings for this contravention? Astha? Yeah, if we come here, then you will notice that the IBBI has held him, guilty of misconduct. You can say they have said that code of conduct contravention is established because they are saying this is in contravention of Regulation 13(1) of CIRP read with clause 135 and other relevant sections. So what probably needs to be noted in this, that though you have taken an, I'm not going to the merits of the case because probably we do not have full facts here, but still what is important to note that in this case, NCLAT has held the RP not guilty because he has acted based on an independent legal opinion, because maybe he was in doubt about the exact nature of the claim. Still, IBBI has held him guilty of misconduct. This is my interpretation. If there are other views to this, they are welcome. But I thought this is an important thing to be noted.
Yeah, very important. Just we cannot say that we have taken legal opinion, but we have to complete our process, and then on a technical ground or interpretation level, I think we can go to lawyers.
Right, ma'am. And a very important thing is
as
that
regards
even
process flow is there, then you are responsible because there was a process flow they found. And if that process flow is not there and you go to lawyer and technically, then it is fine.
right.
Bank on the process flow detection.
And importantly, I also feel that he or she could not take shield behind NCLAT's finding, which held him not guilty, because they thought it is okay that if you've taken a legal opinion and then acted, then you've done your duty. This is, this is part of RP's submission that NCLAT has held him not guilty.
No, but sometimes, when it is difficult to analyze the claim, and sometimes RP have to rely on the opinion of experts.
Right.
I don't think that he has violated or he has acted negligent.
And
Yeah,
this is
that's
more of a common thing. We usually go for the legal opinion.
legal opinion, and I think it has met with scrutiny of NCLAT also, and even they opined, but still the regulator has held him or her guilty. So it's a matter of discussion, of course. But anyway, this is the final finding and probably one of the reasons of disqualification of his licenses. So
Yeah.
I don't know how to deal with these situations, because I'm sure in the kind of cases that we handle, there are all kind of situations, and at times, we definitely go for opinions because we are not sure of the correct course of conduct or correct status of that claim or any other matter for that this thing.
And Devendra, this is the only correct way.
Yeah,
When
of
you are
course,
when you are not in
because
a position to decide something.
decide, yeah, you consult with your team, you discuss, and things are still vague, so obviously you go for such opinions. But if even I don't know, that's what I said, that since full facts are not there in front of us, maybe we are missing something, but it looks a little harsh to me at least. Anyway, we can move
No,
on.
what they are telling that there is an agreement with shareholder, and as per that agreement, they have to deposit the money in escrow account, and that process has followed. So without that checking, you have worked on the claim. So they said, fine, you take legal opinion, whether this kind of process is there and not compliant, we can take the claim. But you cannot just say that claim came and you are not checked the relevant execution of agreement based on which this amount was given.
Ma'am, that's another point. That's a different point actually. In the same case, that's a separate point where that there is a fault. I agree, because there he has taken based on the bank's record, and he has not independently verified the claim of the home buyers. But that's a separate contravention. This is Asta. Can you move to the contravention 2?
Yeah.
Yeah. So this contravention is different, Dipti ma'am. This talks about landowners' claims. And the one that you just mentioned is further down. I don't know which contravention number it is, but that is, about home buyers' claims, which were routed, he kind of admitted them based on the money which had flown in on the bank's escrow account without looking at each home buyer's individual, like we would see a builder buyer agreement and receipts and bank statements. So that exercise it into that, I agree, there is a fault there. I don't know which contravention number it is, but
Yeah, it is.
yeah, so this is contravention 6. This is separate. This I agree that there is a issue here. I agree with the findings here. So these are two different matters.
Right.
Yeah.
Yeah, I think we can go ahead.
Yeah.
But in terms of contravention 2 that you have been referring to, it very clearly states that it's not a financial creditor. That's where, even though you have taken the opinion from otherwise, but principally it doesn't fall under the principal clause itself.
Right. Yeah, that's what IBBI said. I agree. That's what I said, that facts of the case and merits may be there. But I was just saying that NCLAT has held him not guilty. But
still.
Yeah, so that has not been able to save him or her. Yeah.
True.
Yeah, Asta.
We can proceed. Yeah.
Yes, ma'am. In the next matter, the first contravention that was done was by the RP, where he had filed the first progress report with a delay of 126 days, and the second progress report was filed with a delay of 93 days. These progress reports are supposed to be filed within a period of 15 days by the end of every quarter. The RP submitted that the adjudicating authority had allowed the condemnation for the delay, and to which the disciplinary committee intended to take lenient view on this account. The second contravention was for appointment of process advisors. The liquidator may appoint certain professionals for assisting and helping them in discharge of certain duties and obligations, and such remuneration that is paid to these process advisors is always forming part of the liquidation cost. Further, it is observed that the liquidator has abdicated his duty in appointing professional to assist in conducting the liquidation process and allowed the COC to usurp his authority. The RP submitted that in the prevailing market practice at this point of time, the COC members invited competitive bids, and for the same, they had passed a resolution for appointment of such process advisors, which was approved by the COC. The analysis and the findings of such is that the disciplinary committee held that in pursuance of the perusal of minutes of the first SCC meeting, the agenda to discuss the continuation of professionals was placed for consideration, and it is noted that none of the SCC member raised any objection against the issue. Hence, the said contravention is inferential in nature and warrants lenient interpretation. The next contravention is excessive. The next contravention is excessive liquidation cost, including liquidator's fees. Here, the breakup of the liquidator's fee and the fee of process advisors out of the total agreed percentage was forming more than 90% of the fee that was payable to the process advisor. The amount had come down to a tally of rupees 16.5 lakhs over a period of 38 months in comparison to that of the liquidator, which was 5.54 lakhs for the entire period of liquidation. The liquidator submitted that the total fees which was to be paid to the liquidator and advisors were ultimately decided by the COC pursuant to the negotiations after multiple quotations which were received as bids. Hence, it was well informed and considered that it was in the commercial wisdom of the COC members. The analysis and the findings of such is that the liquidator during the hearing submitted that the corporate debtor was not a going concern during the liquidation period. Hence, what efforts or services were provided by the process advisors which required a payment of more fee to pay to the process advisors. It is true that while passing resolution for liquidation of the corporate debtor, the COC had decided the fee of the liquidator and the process advisors. But after getting appointed, the liquidator should have examined the actual requirement, whether should they be included and engaged, and bringing the requirement of engaging the two process advisors and the payment that were made to them in view of the fact of the corporate debtor, that it was not even a going concern. These should have been reviewed by the liquidator. The next contravention is for non-disclosure of appointment of professionals. It was observed by the board that there was a non-disclosure of relationship disclosure regarding the appointment of these professionals. The liquidator submitted that he had disclosed the appointment of these professionals on IIIP CAI portal as per the IBBI circular, which was dated 16 January 2018. However, he specifically pointed out that professionals are operational service providers in normal course of business, providing services in relation to data room and physical record keeping. The liquidator was of the view that these appointments do not fall within the purview of professionals and are not covered under the purview of circular dated 16 January 2018 by IBBI. The analysis and the findings of these are, as per the definition of service under the agreement of professional appointed by the liquidator, it clearly includes professional services. Thus, the contention of the liquidator that both the companies were providing the service to the corporate debtor as an operational creditor and his understanding about the services not falling under the definition of professional services is not acceptable. The disciplinary committee held that the IP has contravened the provisions of the code and the regulations with respect to incurring unreasonable cost under liquidation and making disclosures with respect to professionals engaged. Also, the fact that IP has already surrendered AFA, which has been accepted by the concerned IP. Further, his application for withdrawal of IP registration is also under consideration. The committee directed that any fresh application for new IP registration or AFA as may be submitted by the IP in future to work as a professional under IBC processes may be kept in abeyance till completion of 2 years from issue of this order. Can we move ahead?
I have one query.
Yes, please.
Yeah, whether we should go for the appointment of process advisor actually.
It's
I-
not true. Yeah,
Yeah.
Mr.
No, please carry on, please.
No, the process advisor, if you feel that it is required, with the appointment you can do, as we know, and the cost approval you can take from COC. But as usual, that even though earlier there are cases when that IP fees were approved by COC, IBBI has taken view whether it is commensurate with the size and operation. Under code of conduct will come. The same way here come it will be, whether you are doing in the best interest of the process and all that. And that will be questionable. So process advisor, if required in this case, there was no business. So why process advisor? And even if you appointed, what kind of service you have taken such a huge amount?
No, ma'am, in one case I saw, which was, an order from the IBBI itself. They say when you are a qualified person as insolvency professional with the 10-year, 15-year experience, and you know IBC very well, then what the process advisor can guide you, what extra can a process advisor can guide you?
So many times it is process rather than process advisor to IP as regards the evaluation of resolution plan, technicality, legal opinion, weighting of legal documents, claim verification, this kind of expert advice of which involves somehow interpretation of the rules, regulations, process to be followed, not that day-to-day process advice. But this kind of issue, when there is a lot of claims are there and all that, which has a complex issue, surely you can have a process advice.
Ma'am, one side we are facing the issues of legal opinion in the last order, and so much things are expected from the IP.
And also I have a point here, this case is for the liquidation. And in the case of liquidation, liquidator definitely can ask the comment from the SEC, but he is not supposed to obey with the comments. He can, if he have sufficient justification to disobey the decision made by SEC, he can do the thing. But one thing, he has to make record, and as per the recent circular, he has to inform the adjudicating authority that he has not obeyed by the decision of SEC because of these reasons. So liquidator, I think, has more scope to make such appointment than RP.
Yeah, but again, now recent all the amendment liquidation process also is coming in the line of CRP process. But the thing that any decision you take, so far we have to act, prove it is in the best interest of the CD process. It is just all cost incurred is justified because it commensurate with the services taken accordingly. In this case, that's why in this case that business was not there, and they have taken that. So the kind of activity was not that big, and the amount involved was big. That's why the question.
Basically, the cost issue. Yes, basically the cost issue is there.
And that's why they gone in deep root. That why you need also even this advice. Not that every case. It's a particular facts of the case where they are. So each case is a different.
Yeah, ma'am, my point is that if I make such decision and if I inform the adjudicating authority without any advance remark from them, then is there any problem? Is there any issue for me appointing the process advisor for liquidation? I'm saying, not for resolution.
Exactly here, if you have nothing running operation or anything, but you have to just sell the asset by e-auction, and if you appoint advisor, that will
absolutely
be
absolutely.
So each case is a facts of the case different. So they very well said that if there is no business, what advice you are doing? You have to sell the asset, recover money, and distribute. That is a compliance, that is support system, that compliance support system.
Correct.
Okay, thank you. Yeah, Asta, we can go ahead.
Yes, ma'am. In the next matter, the first contravention that was done by the IP was for lack of efforts in realization against the investment made by the corporate debtor. Now, certain investments were made by the corporate debtor in 4 shell companies, and moreover, the corporate debtor's name was also not being reflected in the list of shareholders. The liquidator made several attempts to obtain the details but did not receive any share certificate. The corporate debtor does not have any other realizable fixed asset, and hence the liquidation value may be taken as a nil. The RP had intimated NCLT under section 66 of the code and also informed the income tax authorities about such transactions. Here it appears that in these circumstances, which have been such that she could not do much to get back to the funds back as evidentiary money trail, was also not available with her, and owing to this, on this account, the disciplinary committee inclined to take a lenient view. Contravention 2, non-opening of liquidation bank account. Since the liquidator had further submitted that no money was received during the CIRP process and that she could not deposit rupees 10,000 for opening of the bank account, for this reason, the bank account could not be opened. The requirements related to compliances are supposed to be known to the professional while taking the assignment, and therefore one can't shield behind the non-availability of the fund as a valid reason for not opening the account was given by the disciplinary committee. Thus, the IP was duty bound to open the account, and for facilitating the same, she should have persuaded the OC for contributing this token amount. The next contravention was excessive delay in conducting the liquidation process. The dissolution application was filed on a delay of 85 days, but it was filed within the period of 2 years of liquidation order, as the liquidator had submitted that during this period, there was a lockdown due to COVID-19. The plea of the liquidator cannot be accepted in the view of the fact that the authority had directed for filing dissolution application in the month of 2019, whereas lockdown had been imposed in the month of March 2020. The committee finds that dereliction of duty on this part of the liquidator is evident in not filing application for dissolution in compliance of the order being passed by the adjudicating authority. The order given by the disciplinary committee was a warning that was issued to the resolution professional to be more careful and vigilant in complying with the directions of the authority in existing as well as future assignments. In a few instances earlier also there have been found where the resolution professional has erred in her judgments. Therefore, the RP henceforth is required to extend rigorous due diligence in handling of various procedures being performed by her under the code.
Yeah, so this case is over. This is, I think, it is a learning for us. Luckily,
yeah, first 3 lines are very,
yeah, I mean,
giving relief.
giving relief. So it is just, I think, these are precautionary notes for us. If we have any similar situations, then probably we need to be a little more vigilant and learn from this. If anything we need to discuss on this, otherwise Astha can move to the next.
Yeah, it's fine, I think.
All right.
Yes.
Yeah, go ahead.
In the next matter, the first contravention is non-cooperation while conducting investigation. Here, the RP failed to provide any specific response as per the investigation and the inspection regulations by not submitting any reply to the notice of the investigation. RP submitted that he was never served or received any draft inspection report. He also submitted that he had uploaded all the documents that the inspection agency has required and are submitted by him via email. The next contravention was excessive fees claimed as a resolution professional. The application was filed wherein an RP had claimed an amount of rupees 3.75 lakhs per month for both self and for his team, besides expenses in a sum of rupees 168.60 lakhs without doing any work. The next contravention is for inconsistency in action and handling over custody to ex-management. The RP has filed an application for liquidation orally opposing the order, opposing for passing an order of liquidation contending to the corporate debtor is viable for resolution. There is inconsistency in his action, as while the RP has filed an application for liquidation of the corporate debtor without the consent of COC, but orally opposed it during hearing, believing that the corporate dispute can be solved. RP further submitted that he was left with no practical functionality and nothing other than liquidation survives. The next contravention is non-submission of relationship and cost disclosure forms. It is observed that there was a delay in submission of the relationship disclosure forms of various appointed professionals to the IPA. The RP demitted office as RP by passing the liquidation order on 16th of November 2002. Form 3 of cost disclosure was not submitted by him, which was to be submitted by the RP within a period of 7 days from demitting office as a resolution professional. The last contravention is for non-submission of the CIRP form with the board. Certain CIRP forms, that is Form 4, 5, 6, and 8, have not been submitted to the board as per the regulation. To this, the order passed by the Disciplinary Committee notes that on several counts, contraventions have been established and hereby suspending the registration of the resolution professional for 1 year.
Discussion, I think, yeah, it's over. I think we discussed enough. Thanks. So in that case, we can close this webinar. Thanks, participant, for your active participation. And we intend to keep on doing this every 15 days. So next webinar will be after 15 days, and we will send you the necessary flyers for the same and the mails. And this will be uploaded on our site. And I will request all the participants, if you have any suggestions or any topic or anything, please write to us. And I will like to state that we should actively participate. It's a discussion platform. It's not the presentation. We are just doing it for the purpose of creating a point of discussion, but it should be a active discussion because each participant is equally competent here. Thank you, Mr. Srinivas, for your time, and thanks for your good work. I hope you enjoyed this webinar.
Yeah,
Yes,
thank you,
yes,
Mr. Srinivas. Yeah, probably we'll bother you for some more program. So probably, we also wanted to see this IBC from the perspective of the, financial institutions. Of course, in your initial remark, you said, that things are moving and all those banks are into profits. But, see, I think most of the participants, they are also, insolvency professional and all. So probably, they wanted to, sometime hear something, from the horse's mouth, how the bankers, look at, from the angle of, as a recovery and as a, how do I say, making this company, kind of a revival. Yeah. So,
yes.
because there are a lot of
Actually, I want to
expectations.
share an interesting fact, like for the banking sector as a whole, IBC has already played its part and it is likely to play a bigger role in future. There's no doubt about that. But so far, the statistics go as follows. Like the recovery for the banking sector, if you see, is coming more from the SURFACE actions, from OTS actions, and the third place is occupied by NCLT resolutions. As of now, the NCLT resolutions are not at #1 position. If you look at the statistics, the recovery being done by the banking sector is predominantly from the OTS proposals or the SURFACE action and disposal of the assets through e-auctions, etc. NCLT resolutions still remain at #3 position only. So the idea should be to take this to #1. And if we look at the recovery percentages, I mean, it's anywhere between say 5% to say 20% only. Exceptions may be there. There are some exceptions where maybe 100% recovery was done through NCLT proceedings also, through resolution plans and all that. But in general, the recovery rates are maybe 5 to 20%. We can say majority, 80% at least, will be in this category, and maybe only 20% are in the above 20% recovery category. So
Sir,
the
why the
pardon?
So why the banks are not inclined to come forward for the COs for the IBC matters?
The expenses and the expected recovery, these are the two factors which are being weighed out in the minds of bankers. We incur a lot of expenses. In many cases, frankly speaking, cases go into liquidation. We do not get adequate number of resolution plans. There is hardly any resolution plan, one resolution plan or no resolution plan at all. And even if one resolution plan is there, it becomes, a buyer's market. The prospective resolution applicant, he is, dictating terms. Bankers are not left with, many choices. So they are forced to go into liquidation. So again, in addition to the CRP cost, the liquidation cost has to be borne. So all these costs, they are weighing out the benefit of expected recovery through liquidation. So all these factors have to be, considered. The resolution professionals also should try to widen the choice for the banker. They should be in a position to generate more number of prospective resolution applicants. So that price discovery mechanism is still very weak. If you have only one player, one resolution applicant, there can be no proper price discovery of any unit. So any resolution professional should try to maximize the responses to the EOI, to the expression of interest Form J which is issued. Like there should be more number of players. This is one area on which RPs should focus to improve the recoveries for the banking sector and also to get, a reputation in the industry and maybe more assignments for themselves in future.
Thank you for your comment, sir. But again, the problem with the RP is also that we give advertisement, we provide mouth of word to give the resolution plan, we say that. But there should be the inclination for, mid-size company. The problem is mid-size company, not a big corporate where the asset book is very strong. They have good asset in the book or a running business. Otherwise, majority time other businesses in a problem, not running, or it's almost closed, or they have very small mid-size, asset. There the resolution plan people are, because the kind of complexity it has. So, the industry, so less interest in mid-size and where the assets is less. So actually their RP is helpless.
Yeah, it depends on the specific case also, as you rightly said, madam. But there are some potential cases where some efforts by the RPs could have maximized the participation in the resolution plans.
Yeah,
and
yeah.
could have created better recoveries for the bankers.
Yeah, yeah. Thank you, Mr. Srinivasan, for your kind words. Thanks for your time. Thank you, Mr. Devendra. And thanks all the participants, partner. And thanks, Asta, for your wonderful presentation. Thanks. We appreciate your effort. Members, participants, please join our next webinar. And this webinar recording will be uploaded on YouTube. So you can go through that. Thanks a lot. Thank you. Thanks, everyone.
Madam, just one word of appreciation for you, madam. Like, I'm happy to hear that every 15 days you are going to organize a seminar like this.
Yeah.
So it is going to be very, very useful for all of us. And whatever insights I have gathered from this program, I'll share with all my colleagues also.
Thanks a lot, sir, for your good words.
Thank you.
Thank you, everyone, for organizing this wonderful program.
Thank you, sir.
Thank you, sir.
We learned from LinkedIn, your post on LinkedIn.
Thank you. We'll send a mail flyer.
That today only I saw the LinkedIn and immediately registered.
Next program will be, thanks a lot for your prompt response. Next program you'll get in advance only, sir.
Thank you.
Thank you.
Dipti.
Yeah.
Rajesh Sheth is an ex-SBI DGM.
Yeah, sir.
Huh.
Hello.
Hello?
Yeah. What
Rajesh Bhai is an ex-DGM of State Bank and looking into stress assets.
Oh,
He's now connected
sir.
with Deloitte.
Oh my God. So we are fortunate.
that is irrespective of that. That doesn't take away the value of this webinar.
Thank you.
Webinar topics were that is first is the orders and then disciplinary proceeding. These are the two main things which will help all the IPs to not to make these similar mistakes. Because that is the, I think, take home learning from this webinar. We should not, all of us, we should not make same mistakes. And
right, that is the purpose, sir. You rightly summed it up. That is the purpose of this webinar. Exactly. It is learning for all of us.
Yeah.
Thank you.
Thank you. Thank you.
And good work. Thank you.
Thank you.
Thank you.